Hello and welcome to Nationwide on the network service of the NTA. I am Kendi Olale. Thanks for joining us. The Presidential Election Petition Tribunal has reserved ruling for Wednesday, 3rd July on the application of the People's Democratic Party and its presidential candidate Atiku Abubakar, urging the tribunal to allow them join issues with the All Progressives Congress on a motion to dismiss the PDP petition. The 5-member Presidential Election Petitions Tribunal, led by Justice Mohammed Garba, gave the verdict at the resumed sitting on Monday. Dele Atumdim reports.
The PDP and its candidate through their lead counsel, Livy Uzogu, moved the application filed on 18th June 2019, pleading with the court to give them the opportunity to join issues with the APC on its motion pending before the court, filed on 15th May. The APC in this motion, which was initially unchallenged by the PDP, is urging the court to dismiss the petition of the PDP and its candidate at the pre-hearing stage. Though the petitioners through their counsel joined issues with the APC on its application filed on 14th May, which the respondent has withdrawn from the court and elected the one it filed on 15th May, which the petitioners did not join issues with and merely raised objection on its purported similarities. This the court took judicial notice of on the petitioner's inability to join issues on this matter within 7 days as stipulated by law. However, in the interest of justice, the petitioners are urging the court to give them the opportunity to reply the APC on the matter. Counsel to President Muhammadu Buhari, Wale Olanipekun SAN, who objected to the application, appealed to the court to dismiss it. Lateef Fagbemi SAN, counsel to the APC, and Ustaz Usman SAN, counsel to INEC, also objected to PDP's application. Ruling of the court on this matter will determine whether the sitting of the Presidential Election Petition Court will go beyond its pre-hearing stage on the PDP petition. During the trial proper, the PDP is proposing to call 400 witnesses. With the consent of all the counsel, petitioners will have to prove their case within 10 days instead of 14 days, while respondents will have to present their case within 6 days instead of 10 days. The counsel equally proposed trial to commence on Thursday this week. In Abuja, Dele Atumbi, NTA News.
Still on tribunal matters, senatorial candidate of the New Nigeria's People's Party, NNPP, for Bauchi North Senatorial District in the 2019 National Assembly election, Farouk Mustafa, has tendered 2 bags of documentary evidence before the National Assembly Election Petition Tribunal sitting in Bauchi as part of efforts to prove his petition against Adamu Mohammed Bukachwa of the All Progressives Congress, APC, INEC, and 2 others. Adamu Aruna Adams reports.
Farouk Mustafa and the New Nigeria People's Party filed a petition before the National Assembly Election Petition Tribunal for Bauchi State, protesting declaration and return of the first respondent, Adamu Bukachwa. In the petition, the petitioners maintained that the results announced by INEC for the said election did not conform with what actually transpired on the 23rd February 2019 in Bauchi North Senatorial District. They therefore prayed the tribunal to declare the first petitioner, Farouk Mustafa, as the duly elected candidate of the election, having scored the majority of lawful votes cast. In the alternative, the petitioners urged the court to nullify the election and order for fresh election in the senatorial district.
We've tendered the duplicate originals, some of them that were given to the polling agents at the polling units. Then the certified true copies of the ones we got from INEC.
The approach they are taking is to fast-track the hearing of the petition. So with the turning of documents, I'm sure by the time witnesses come to give evidence, it will become a lot easier.
The matter has been adjourned to 16 and 17 of July for continuation of hearing. In Bauchi, Adam Haruna Adams, NTA News.
The Federal High Court sitting in Lagos has ordered fine of forfeiture of 9.2 billion naira and $8.4 million traced to bank accounts belonging to Patience Jonathan, wife of former President Goodluck Jonathan, to the federal government. Justice Mojisola Olatorigun, who delivered the judgment, said the former First Lady failed to show cause why the money would not be forfeited as proceeds of unlawful activity. Vera Chumaba, who was at the Federal High Court, has more.
The Economic and Financial Crimes Commission, EFCC, had secured an interim forfeiture of the sums in April following a motion ex parte. Joined as respondents to the suit are Patience Jonathan, Globus Integrated Services Limited, Flinchie Top Homes Limited, AMPM Global Network, Pragma Oil and Gas Limited, Magel Resort Oil, and Esther Oba. EFCC counsel Rotimi Oyedapo had in October 2018 moved a motion for final forfeiture of the sums. The commission had alleged the firms were not into any income-yielding legitimate business venture to earn such amount, but rather they were incorporated for the purpose of concealing proceeds of unlawful activities of the former First Lady. Defense counsels Ifedaya Adedipe and Mike Uzokome had opposed the application. Justice Mojisola Olatoregu had directed parties to give oral evidence to explain the ownership of the money. The court had admitted electronic evidences presented by the respondents' counsel, which depicted video exhibits showing various business outfits of the respondents to justify the source of the funds. Justice Olatoregu, while delivering the judgment, said Patience Jonathan failed to show reasonable cause why the money should not be forfeited to the federal government as proceeds of unlawful activity. Also, in trial within trial, in the case of Ondo State Chairman of PDP, Clement Faboyede, and Modupe Adetokunbo, the Director General of the party's 2015 state campaign, a member of the EFCC investigation team told the court that the defendants made their statements voluntarily, contrary to allegation that the statements were obtained under duress. Both are facing charges of money laundering brought against them by the EFCC. In Lagos, Vera Chumuba, NTA News.
Well, it's been 3 months after the 2019 general election and still no political party has submitted its financial report as required by the Electoral Act. The Independent National Electoral Commission, INEC, is to deploy some legal means to compel erring parties to oblige. INEC Chairman Professor Mahmoud Yakubu renewed the stance of the Commission in a meeting with political parties leaders in Abuja. The issue of deregistration of political parties was also discussed.
I wish to remind you that the Electoral Act 2010 as amended requires each political party to submit 2 election expenses report to the Commission. First is the disclosure of material contributions received from individuals and corporate bodies 3 months after the announcement of results of the general election as provided for in Section 93, subsection 4 of the Electoral Act. So far, no political party is in compliance.
The more political party participating in an election, the less post-election violence and bloodshed we have had. We therefore believe that parties should not be deregistered. But sincerely, in our view, we believe that the registration requirement for associations seeking to be registered as a political party should be made more stringent and reviewed immediately, instead of registering political party and then deregistering them within a short while.
The review meeting with stakeholders is part of effort by INEC to come up with a central document in addressing some of the challenges experienced in the 2019 general election. Assent to Companies and Allied Matters Act repeal bill passed by the 8th National Assembly and before the President for signing will be an added impetus to the present administration's anti-corruption credentials. The Civil Society Legislative Advocacy Center, in collaboration with 10 other civil society organizations were of this view as they re-examined the impact of the bill on the nation's economy. Our Musa Rafsanjani, on behalf of the group, said the ultimate goal of the bill is the establishment of comprehensive database of real ownership behind the management of private companies operating within Nigeria's jurisdiction.
If you don't have beneficial ownership register, in the first place, you need to know who owns what, who are the people behind, the companies. It is only when you have a legal framework that you will be able to establish Mr. A or Madam B owns X, Y, Z properties.
The bill has only been this week assented to by President Buhari. The lack of proper supervision, monitoring, bad management and gross misconduct has been highlighted as some of the problems confronting Nigerian banks and not necessarily capitalization. These were the submissions by some guests on NT's Good Morning Nigeria on the issue of central bank's proposed recapitalization of commercial banks in the country. Alika Okpanachi Aroa has details.
It's believed that for banks to be able to perform their traditional role as financial institution, satisfy the customers, and be able to withstand internal and external pressures, recapitalization is necessary for strong capital base.
The very definition of recapitalization, implicit in it, is the fact that a return to the required capital base or former capital base, or an increase in the value of the capital base.
The proposed recapitalization of banks in Nigeria is a strategic move, is a proactive move by the Central Bank of Nigeria to strengthen the banks